Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about police excessive force. Cases that should have gone to the Supreme Court of Canada, but didn't. Mr. Stanley was subject to the execution of a search warrant on his home after there were tips given to police to indicate that he had unlawful firearms there. When the police executed the search warrant, Mr. Stanley alleged that they pinned him to the ground and held their foot on his neck while they carried out their search of the home. No firearms were located, nothing illegal was found. Mr. Stanley filed a complaint with the Toronto Police Service, arguing that they had used excessive force in carrying out the search warrant execution. At the time that the matter was heard, the tribunal ultimately determined that Mr. Stanley had been the subject of excessive force by police and that the police were wrong in their conduct. They issued a determination in his favor. After the determination was made, one of the police officers, the chief of the Toronto Police, alleged that there had been a transcription error in the interview with one of the investigating officers who was alleged to have been involved in the execution of the search warrant and involved in the incident, and submitted the corrected transcript, incredibly suspicious, to the tribunal, asking them to reconsider their decision. The tribunal agreed, reopened the investigation, and dismissed the complaint as unfounded on the basis of the corrected transcript that was submitted after the fact and after the initial determination. Mr. Stanley appealed, arguing that the tribunal had no ability to reopen the decision, to hear new evidence after the fact, and to change their ultimate determination. And this case went all the way to seeking leave to the Supreme Court of Canada on the question of when an administrative tribunal has the power to reopen a decision for fresh evidence and in what circumstance. And this is an incredibly important issue. Although there have been some recent decisions from the Supreme Court of Canada about the powers of administrative tribunals to reconsider, none of them have considered that power in the context of fresh evidence. How fresh evidence, under a reconsideration power, if one exists, is to be considered, the impact of the fresh evidence on the original decision, and the process that should be followed. And unfortunately, as the law stands in Canada right now, if fresh evidence is discovered after the fact, then that fresh evidence needs to go through an entire process of bringing an application for judicial review in a Supreme Court and having a judge determine whether or not the fresh evidence should be admitted on the application for judicial review, only with respect to the questions of the reasonableness or the correctness of the decision maker's ultimate decision. This is an incredibly limiting process that can lead to unfair results. And obviously the circumstances here don't exactly sound the most straightforward and upfront, but there are numerous situations in which administrative tribunals might be asked to hear fresh evidence and unable to do so as a result of decisions like these, situations that involve the very core of the fairness to the parties in the proceeding. There are lots of tribunals that are incredibly constrained in the amount of time that you have to gather your evidence, submit it, prepare for a hearing, and even to present your arguments at the hearing. And so a fresh evidence test is absolutely something that should be taken into consideration in these circumstances. It's unfortunate that the Supreme Court of Canada didn't take the opportunity to hear this question about when and how fresh evidence should be admitted in administrative tribunal proceedings, and whether or not there is a power to reconsider when fresh evidence exists, because this would allow more people to access justice through the administrative proceedings rather than have to go through lengthy and expensive litigation in Supreme Courts, only to find that it doesn't lead to any ultimate remedy for them in the circumstances. This was a case, in my view, that should have gone to the Supreme Court of Canada to try and make the use of administrative tribunals in Canada more fair and to address concerns about police misconduct, particularly as it pertained to the facts of this case. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.